understanding law. Law is what? Law are the conditions. Law are the conditions which are necessary to maintain as a balance in society. Balance in society, for which has we use a law. Am I audible? Law, these are the conditions which are necessary for a make the balance in society. For the maintenance of a law and order, the judiciary is responsible for this. Judiciary is responsible for this. Law has generally has formulated or the passed by the parliament. When the resolutions and a bill passed by the parliament is known as a law, and that law is a universally accepted. Nobody it can't deny to use as a law. Law is applicable on all those citizens which are living in India. Those citizens which are living in India, they will follow those law which has marked by the Constitution of India. So after the independence, the crucial stage of just after the independence of India, it was as the making of the Constitution of India. That Constitution which make the possible changes in that structure which earlier not followed during the British age. Because in a British age, there were the most number of the law were restricted the social freedoms of people. Social freedoms of people. Britishers were enacted during the colonial rule a number of the law which restricted the freedom of Indians, in which some of the examples are Sedition Act of 1870. Sedition Act of 1870. Sedition Act of 1870. Vernacular Press Act. Vernacular Press Act 1878. Rowlatt Act 1917. 1917. So such type of the law were introduced at the time of a British age. At the time of British age, so these laws restricted the social freedoms of Indians, in which as a first Sedition Act, in this act states that if any of a person protesting or criticizing the British government, their policies, it can arrest without any trial, without any permission. It can be arrested or sent behind the bars. It can send behind the bars if a person has protesting, show their aggression against of the British policies. This was as a Sedition Act of 1870. Afterwards, the Britishers enacted as a Vernacular Press Act. Vernacular Press Act of 1878, which states that if any of a media, the means of media means radio, television, or a newspaper, if any of a media has criticized the government policies, the British policies, under such circumstances, their functioning, it will be as a restricted. This was as a Vernacular Press Act of 1878. 1878. Third Act, the Rowlatt Act in 1917 states that if anywhere, if in any of a public place, whereas two individuals are standing and discussing any issue, it can be as an arrest without any trial. उनको arrest किया जा सकता है. They can send behind the bars without any prior information. Means after the independence of India, that custom of an arbitrary rule finished. If a police has arrested a person, for this it needs as a what needs by the police at the time of the arrest of a person? Yes, Ritesh, क्या कहते हैं उसको? What we call to it? बच्चे, we are talking about the understanding law, Pragati. Understanding law, next chapter. When police has arrested a person, it needs a kind of a document on such behalf it can arrest the person. Otherwise, not.
Arrest warrant.
Arrest warrant. 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 Warrant is what? This is as an order. Magistrate's order. On this order, on the behalf of the order, police can arrest a person. It means police independently, it can't arrest any of a person. But there is as the condition, there are basically two kinds of the offenses are there. Offense means when a person has breaks a law. A person which has not follow a law, it breaks a law, it has doing as a illegal activity. It means as a the person has breaks a law. That condition is known as an offense. There are two kinds of offenses are there: cognizable offense and non-cognizable offense. Cognizable and non-cognizable offense. Non-cognizable offense. What is as the difference? Cognizable offense are those offenses for which the police do not require the arrest warrant. So police, it can arrest a person in that state where it has not required as an arrest warrant. So what are the cases in which as a police can arrest a person without any arrest warrant? Robbery, theft, murder, kidnapping. For such kind of situations, for such kind of offenses, police do not require a warrant. Warrant means जब आपको arrest किया जाता है, you can ask to the police that where is the arrest warrant. On behalf of the arrest warrant, the police can arrest a person. It can arrest an individual. That document has signed by the magistrate, the judge of a session court. It will pass that order. Clear? So these are the cognizable offenses for which the without any arrest warrant, a person can arrested by the police. A person can arrested by a police. But there is a condition. There is a condition. If the police has arrested a person, women, at that time the women constable, it should be as a present at the time of the arrest of a women criminals. Or there is also one more condition is there. Under such circumstances, when a woman has arrested, it will be present in front of the magistrate within 24 hours. If the police has failed to present the women in front of the magistrate, judge के सामने पेश नहीं किया जाता है, under such circumstances it will release her. पर फिर भी अगर if a woman has kept in a police station, under such circumstances there will be the women police constable, it will be present throughout their time. जब तक वो women police station में है, there will be as the presence of a women constable. वो वहीं रहेगी, ठीक है? So conditions are there with the those which are breaking a law, because law is a universally accepted. Yes.
सर वुमेन को हम 6 बजे के बाद नहीं ना अरेस्ट कर सकते?
मैंने कहा 24 आवर्स के बीच में उसे मजिस्ट्रेट के सामने प्रेजेंट करना होगा. Not as a condition as a 6 o'clock, within a 24 hours. For example, a woman which is arrested in a Saturday afternoon, just after at the time of the evening, courts are shut it down. Under such circumstances, next day as a Sunday, and a Monday as there is a gazetted holiday. Under such circumstances, police will release a woman, that woman which is arrested by the police, clear, on behalf of the report, which is known as a FIR. And non-cognizable offenses are those for which the arrest warrant is mandatory. Arrest warrant is mandatory. For example, the cases of disputes, fighting cases. Under such circumstances, the arrest warrant is required. Arrest warrant is required under those conditions when the disputes are arise in between of a people. In between of people, when the disputes are arise, under such circumstances, the police required as a warrant. These are non-cognizable offenses. These are known as the non-cognizable offenses. Clear? So during the British age, offense means when a person has breaks a law. A person which has not followed the law, it makes as the offense. It makes the offense. A person which has breaks a law, it has makes the offense. For example, a person, there is a child whose age is 15 years old. You are in a 14 years, 8th standard as a 14 years. If a child of a 14, 15 years old, it has driving the two-wheeler, two-wheeler, it has making the offense. According to the law structure in India, this is the offense. A child of a 16 and above age of 16, for them as a learning license as provided by the transport department. But there are individuals which are of the 10 years, 11 years, 12 years, they are driving as a Activas. This is as offense. They are breaks the law. They are breaks the law. Clear? And there is a similar punishment for those which are breaking the law, which are not following the law. But at the time of a British age, most number of laws were there which were restricting the social freedoms of people. They were not allowed to them to work as a freely in country. Clear? Even the Britishers were given as an opportunity to the limited number of people to cast their votes, through which they can elect their representatives. Elect their representatives. And those laws which were enforced in 1950 by the enforcement of an Indian Constitution, now these laws, it can be as a modified in present. We can't change as a constitution, but constitution's property is there, constitution's feature is there. We can modify the parts of the constitution, means those laws which were enforced in 1950, we can modify as per present, which is known as an amendment. Which is known as the amendment. A number of examples are there. Till the present, there are 104 amendments took place in the Constitution of India. 104 amendments. Amendment means to change in an existing law. Change in existing law. Clear? For example, at the time of 1950, there was a law was there, Hindu Succession Act, which says that only as a males can take as share in their parental property. But as per the amendment of a Hindu Succession Amendment Act 2005, which states that now the girls can take share in a parental property. Earlier in 1950, the law was made for a protection of a women in a domestic lives. Domestic lives, which includes as a physical abusement. Physical abusement has categorized under the domestic violence. Those women which are beaten by their in-laws, by their husbands, it was covered under the domestic law. But as per the changes in 2009, there are changes that now the verbal abusement, if the abusive language, if the women has filed a case against of their in-laws that their in-laws are used as an abusive language against of that particular women, then such circumstances a case can file against of the in-law and the husband. This is as a modification. When a law has not suitable for a present society, as per the present needs, when we modify the law, is known as a, when we modify the present law, previous law implemented in country, as per the present needs, is known as amendment. Is known as amendment. Clear? Till there, any questions? Yes, Ritesh, any question? Yes, anybody? Any questions still there? Afterwards, next is a law making procedure, which we discussed in a previous chapter. Law making procedure. Law making procedure has runs through the 3 readings in each and every house. Lok Sabha, Rajya Sabha, through the 3 readings. In first reading, the law will, that particular situation which has need to be made as a law, that is known as a bill. If the assembly in session, when the assembly in session, under such circumstances, the bill will introduced by the ruling party in a Lok Sabha. There will be as an introduction of a bill in a Lok Sabha. Bill will introduced by the ruling party. Their copies will distribute among all the members, including the ruling and the opposition party, and detailed description will given by the ruling party, the minister of a ruling party. For example, the country has needs a newer bill associated with the education. Then Education Minister of India, it will introduce a newer bill or a newer policy in a Lok Sabha. It will be as explained by the ruling party. In a second reading, there will be other discussions, debates are organized in between of a ruling party and the opposition party on against or favor of that particular bill which has introduced by the ruling party or their minister. Education Minister, which has introduced in a first reading, on which the debates and discussions will held in a Lok Sabha. Clear? Afterwards, if the assembly has considered the bill needs the changes, then it can suggest the recommendations If the bill needs some modifications, it can be suggested by the opposition or either the ruling party, the members of ruling party. On behalf of such changes, again the bill will again introduce in a third reading, again in an assembly in third reading, under which with the changes suggested by the opposition and ruling party, again the bill will introduce in an assembly, then there will be as a decision will taken by the speaker of an assembly. Either a bill is passed or not. It will be as a decided on the basis of the sound motion or the voting. Through the voting, speaker will consider that the bill is passed or not. The bill is passed or not. Clear? Afterwards, after when the Lok Sabha has passed a bill with the changes, then again the bill, it will be introduced in a Rajya Sabha. Same procedure will follow. First reading, second reading as a discussions, and third reading as a approval. With the changes, the Rajya Sabha, when it will approve the bill, under such circumstances, it will send towards the president for its consent, the approval of the president. If the president of India has rejected the bill, under such circumstances, bill again, it will be as a discuss in a Lok Sabha, then the Rajya Sabha. If the president of India has approved, given their approval in favor of a bill, under such circumstances, the bill becomes a law. Bill will becomes as a law. Clear? And under such circumstances, as a judiciary will check that that particular law has followed by the people or not. When a people are not followed the bill, means a bill again, sorry, people are not followed the law, under such circumstances as a law needs as a changes. Such kind of a law are known as a controversial law. When people are showing their aggression against of the law which has passed by the parliament, through the public rallies holding as a meetings, public meetings. Third way is signing campaigns. They will sign as a documents and send towards as a government authorities. So through these ways, the people, it can show their aggression against of those laws which are passed by the assembly, which are passed by the parliament. So those laws which are not followed by the people are known as a controversial law. These are the unpopular law, controversial law. For such kind of the situations, the judiciary has played a crucial role, which is responsible for maintenance of law and order. Maintenance of law and order. When a people are not following a law, means the bill needs as a changes, that law has needed a changes, it can be as a modify if the judiciary has considered. If the judiciary Supreme Court has considered the law needs the changes, it can return back towards the assembly, or either the president of India, it can consider and return back towards the assembly again. If the problem has creates among the citizens regarding to follow a law. Japji asked that if there is a people in India, they deny to use, you can't use here the bill. Japji said if both the houses, Lok Sabha and Rajya Sabha, they are not in favor of a bill, then the bill will reject. Japji, if the bill has not followed by the members of a ruling party or opposition party, means that condition has not desired by the country. Not desired by the country. मैं एक example दे रहा हूं आपको. This is not as a law in our country. In our school, there are 4 sections are there. 8, A, B, C, D. Got it? 4 sections are there. If we divide if we divide the classes, all the whole of the 8th standard on the basis of the marks, those which are scoring as 80 and above marks, it should be in 8th A. Those which are scoring as the 40 to the 80%, it should be in a 8th B. And those which are scoring as a less than the 40%, it should be in a 8th C section. Agar aisa divide kar diya jaye. If that kind of a situation will introduce in a parliament, then the people will not accept it. The elected representatives will not follow this. What is the reason? Because Why do as a politicians or a people are not favoring the such kind of a situation? Anybody? If we divide the classes in all the schools on the basis of the marks, why do the people as not follow it? Yes, Chahat. Chahat and Jayant, raise your hand. Rhythm also. Chahat, Rhythm and Jayant, raise your hands. Jayant, are you follow that pattern? If the government takes
नो सर, बच्चों के साथ डिस्क्रिमिनेशन होगी कि हम एक को
it will be as a
सुपीरियर
discrimination. Okay, got it. First point clear. It will be the discrimination with those which will be as a part or the consider in a C section. Okay, anybody else? Rhythm, Garg.
अंदर है, अभी नहीं खाए।
Rhythm. Navkaran, raise your hand. Navkaran Singh. It will be as the stereotype thinking. So such individuals which will be categorized among the C section, they can't. They will feel as a stereotype, as inferior. They will feel as an inferior. It can't be uplift themselves. They can't uplift themselves. Clear? अब इसका एक पॉजिटिव एस्पेक्ट भी है. हमने नेगेटिव बता दिया. अब पॉजिटिव क्या है? The person which will be categorized among the A section, it will be needs as a extra attention to their teachers. Means there are a different number of individuals are there. When basics are, for example, maths में अगर बात की जाए, there is a child which is not know about all the tables till the 20. A child which is scoring as a more than 80%, introduced in assembly, but the assembly has rejected. Why? Because it makes as a discrimination among the people. So in such situations, Japji, they are not becomes as a law. Clear? Only as those situations are passed by the assembly, which are followed, which are related with the large scale of population. Clear? When people are not followed the certain type of conditions passed by the government, passed by the authorities, then they starts to criticize the bill, criticize the law publicly through the public hearings, meetings, they organize the rallies. Through these ways, they oppose the government policies, government rules and regulations. When people are express their anger against of the government policies, they express their thoughts against of the government rules, law and the policies, that is known as a public opinion. That is known as the public opinion. Clear? This was our chapter, Understanding Law. Any questions still there? Any questions? Yes? Anybody? Our next chapter is a judiciary. So let's continue the judiciary. Judiciary is a third important organ of the government. Which we discuss in the features of a constitution as separation of powers. In constitution, there are the powers are divided among the various authorities. At the different levels, there are the powers divided among the central government, state governments, and the local self-governments are there. On the basis of the organs, different organs of government are there. Legislatives, and judiciary. Ritesh, complete the blank. Legislatives, legislatures, and judiciary. वही तो पूछा है सेकेंड वाला. Legislature, and judiciary. Khyati, Japji, then the Pragati given correct answer. Yes. Hurry up. Type your answers. Japji, Khyati, Khurana given correct answer. Pragati given correct answer. Yes. Send your messages in a chat. Yes. Very good, Ritesh. These are executives. Legislatures, legislatives, executives, and judiciary. These are the three organs of government. This chapter, next chapter is the judiciary. It is the third organ of the government. Legislatures makes a law. makes a law, executives execute, implements a law, judiciary has checks that the law is followed by the people or not. If the law has not followed by the people, means the law needs a changes. Under such circumstances, the judiciary can return a law towards the assembly, towards as a Lok Sabha or the Rajya Sabha. Towards the Lok Sabha and Rajya Sabha, assembly can return a law. It can return a law towards the Lok Sabha or the Rajya Sabha for the reconsideration with suitable suggestions. What suggestions are desirable? So judiciary has played a very crucial role in India, which is responsible for the impartial works. Clear? Judiciary, all these matters are sorted out by the judiciary in India. Clear? Judiciary in India. Or other disputes are the citizen disputes where the fundamental rights violated by the government, by the authority. These matters, these disputes are resolved through the judiciary. Clear? Judiciary is also responsible for to safeguard the fundamental rights. To safeguard fundamental rights. If any of the individuals' fundamental rights are violated by the authorities, such matters can directly introduce in a Supreme Court. Fundamental rights means right to expression, right to freedom. Under such circumstances, a person can directly file a case against of the authorities in a Supreme Court. For this, as a judiciary has appointed, judiciary is also responsible for the reviews. Those decisions which are took by the lower courts, their decisions can challenge in a higher courts, either in a high court or a Supreme Court. For example, there is an individual whose case has sorted out against of him. Under such circumstances, that particular person which is arrested by the police and the lower court has proved that the case against of that particular individual, it can appeal in a higher courts. It can appeal in a higher courts, high court or a Supreme Court for a justice. It may be possible that due to the lack of evidences and proofs, a person considered as a guilty by the lower court, by the session court. But as per the existing changes or availability of proofs and witnesses, the High Court can change as the decision which earlier took by the lower courts. If the Supreme Court has took as a decision, again a person has filed an appeal. It can file as a petition in a Supreme Court again. Under such circumstances, the punishment, it can be as a modified. The death punishment or a lifetime imprisonment, it can be as a changeable. It can be changeable. Yes, Jayant?
सर एक पटियाला हाउस कोर्ट भी होती है, मैंने न्यूज में सुना है, वो क्या होता है?
Wait, Jayant. Yes, now.
सर एक पटियाला हाउस कोर्ट भी होती है, मैंने न्यूज में सुना है, वो क्या होती है?
Patiala House Court सुना आपने? In Patiala, there is as the session court. Each and every districts are having their own session courts, like your session court in Jalandhar, in Hoshiarpur, in Kapurthala. Each and every districts having their own high courts. They are related. आपने न्यूज में इस कॉन्टेक्स्ट में सुना होगा, कोई केस होगा, that case which has associated with the large scale of the population, जिसको PIL कहा जाता है, public interest litigations. Such matters, when they are filed, such cases are filed in a session courts. उस context में आपने ये सुना होगा Patiala House Court. Clear? Otherwise, there are 3 levels of the courts are there. One is the Supreme Court, which is the apex court of the India, which is situated at New Delhi. Second, there are the high courts are there. High courts, 23 high courts are there. Each and every state, whereas their capitals are situated, these capitals are the location of their high courts. High courts, for example, Punjab, Haryana having the common capital, so their common high court has situated at Chandigarh. But the northeastern states, Sikkim, Assam, Meghalaya, Arunachal Pradesh, Nagaland, Mizoram, Tripura, and Manipur. These 7 states, northeastern states, are having as a one common high court has situated at Guwahati. Except them, the other number of states are having their own separate high courts. Clear? Except the case of Punjab and Haryana and the northeastern states, other states, all the other states are having their own high courts. For example, Bhopal as the Madhya Pradesh, their capital, their high court, and Ranchi, Raipur, Odisha, Bhubaneswar. So all the states having their own high courts, which are responsible for the proper functioning of a country, proper functioning of the states and maintenance of law and order. Maintenance of law and order. Till there any doubts? Yes. Till there any doubts? Rest we will do on tomorrow. Any doubts till there? Next part is there are two kinds of the law are there. Cases, civil cases and criminal cases. Civil cases and criminal cases. Two kinds of the cases are there. Criminal cases or criminal law. Criminal cases are deals with the offenses that are committed against the society. Criminal cases are those cases that are committed against our society. And the civil cases, these cases are those general law. It solves the disputes between the two organizations and individuals. Clear? First difference, it resolves the disputes in between of our two organizations and individuals. The criminal cases, Government of India that needs to file as a petition on such cases. But in the other side, the civil cases, there may be an individual or an organization can file a case against of the individuals. Clear? For example, a person which has committed as a murder, a person which has arrested on behalf of the murder charges, under such circumstances, the case will present from the side of that particular family whose family member has lost, or either as a government. From the side of the government, case will be filed. It will be filed in a court. But in the other side, civil cases, the individual or organization against of which as a crime has happened, they can file as a case. Clear? In a criminal cases, the criminal law has punishes the convicts, protects the citizens and ensures law and order in the land. But whereas a civil law is protect the rights of an individual or organization. Clear? Fourth, as a criminal cases are associated with the non-cognizable offense. Criminal cases are a cognizable offense and civil cases are the non-cognizable offense. Then afterwards, the example you can write fifth example. Fifth difference as the example. Criminal cases, theft, murder, robbery, and the fighting cases, it will be included under the civil. Divorce, it will be categorized under the civil cases. Clear? 5 differences.